Yes, Mr. Demanding.
Well, it's, if your lordships have the paper book for 41, if I can trouble you to take the IA, my lord, 37419 of 25, which is fine in that. Your lordship will find the papers there. Your lordship's clarification orders dated 10 December 24. It's at page 45
Of the IA.
of that. Page 45. And it's a one. And 46. I can just read that short order. Page 45, 46, para 1.
Yes, please.
Yes. The grievance not be raised in behalf of the review petition of some of the applicants, the full scope, is that though they were in employment covered by the recognition order in so they believe that the judgment of order dated 28th November would come in their way if they want to make better their prospects by applying either in other institutions or for promotional level. We have already clarified the judgment of the region that the one-time scheme was provided solely to safeguard the interests of those teachers who were employed on so-and-so day. We are therefore not inclined to entertain the present review petitions as well as miscellaneous applications. However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10th August 17 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. Needless to state, the clarification will be effective from the date of pronouncement of the judgment under review. The date of the judgment under review is 28th November 2023. Now, the advertisement in question here is 29th May 2024. Please note that it's 29th May 2024. And that was for 2,900 vacancies for which a recruitment advertisement 29th May 24.
29th May 24.
20. And so principal judgment is 28/11/23. So since this clarification applies from there, we have the right to be considered towards this advertisement and for the counselling processes that start. A similar issue rose with reference to Bihar, in which
you were in employment on 10th of August.
No problem. We were in employment in 2017, no cable on that count, it's admitted. We were in service and we have done the 18-month course as required by the timelines provided under the RTN. All that is not in dispute. Now, in Bihar, when the same issue arose, it came to this court, and if your lordship will see at page 52, just 10 days after your clarification out of 10th December, on 20th December, page 52, Annexure 82, dated 20th December. An application was passed. I had occasion to assist the board. At page 53, in fact, at the top of page 53, second sentence, since the Bihar Public Service Commission had issued an advertisement of 7th February 24 for recruitment so-and-so, which is to commence from 23rd December. It is submitted that around 36,000 candidates are in the fray. And the present application is made in behalf of around 215 applicants as well as the stand of the NCT and the NIOS is both recorded there.
They are supporting you, yes.
Yeah, this one. So para 4 extracts the clarificatory order notes. Para 6. In the interim, we deem it appropriate to allow the participation of the applicants in the counselling process being conducted by the BPSA. The outcome of the counselling process, so far as the applicants are concerned, be kept confidential. This is made subject to further orders to be passed to this applicant. Now, if I can pause for a minute and bring you up to speed what's happened to Uttarakhand. After that advertisement, they have had a series of counselling that are taking place. In the counter affidavit, because this application is coming up after notice. Notice was issued in the transfer petition first, and then in this IA. The notice in this IA was on 19th February, after which they have filed a counter, the state. Now, in the counter at page 11, the state says that the counselling process is 90% complete. Independently, directly, we find an RTI and we find at page of the same application at page 95, you'll find there are 278 vacancies at the moment. I'm not troubling you lordship with the pages of the reply, so that they can leave. Just as of the same application, page 95, it's an RTI response. The relevant is at page 96. Bottom of page 96, very last row, it says total number of vacant posts. Last column is 278. So 278 is the number of vacancies. Now, before your lordships, I represent 239 of them. I believe that without in any way disturbing those who have already been counseled, etc., which I would be entitled to ask for, but I don't want to ask for that. Let's not disturb what's already happened. If you've counseled 90% of them, you have 278 present. We are just seeking implementation of your lordship's order. I have copies of a list which shows how your lordship's clarificatory order posts that these have been implemented in the other states of the country. Just give the other side. We've just a little bit of a deep dive to find out what the other states have done. So post your lordship's order of 10th December 25. Punjab has implemented on 2nd January and then again on 4th February. West Bengal has required an order from the High Court 13th January. That's for one individual, West Bengal. Bihar has done it on 7th February and this order also your lordship saw. Jharkhand is 10th February, Chhattisgarh 12th February. The KVs have done it on 13th February. NCT has issued a letter also on 27th January. Now, in this line of growth, I believe that the same order should be passed where we can be accommodated. Because that's the reason. And we are the same petitioners who came before you with that review. Same people who have got the benefit of that. Now, at the very least, that should be implemented by the state. I don't know why they're dragging their feet on it. Yes, madam.
My lords, I did not have the benefit of appearing before my lords when the parent judgment and the review order was passed. But my lords, what is being sought right now is a clarification as to interpretation for the review order.
No, they are only seeking the implementation of our review order, which we have clarified by the review order. We did not enter in the review, but we clarified our order.
To the extent, my lords may kindly see the review order and rather enlighten us as to what will be the interpretation, my lords, because the state will be is in compliance of the parent judgment. Who are the which basically upholds my service rules. My service rules are in consonance with the guidelines.
Therefore, we held that the special scheme was in order to protect those persons who were already in service on such and such date.
My lords,
we have, I still maybe distinctly recollect the judgment. The correspondence between the government of India and the various authorities, the Nios and all that, was to provide avenue to those persons who are already in employment, so that they are not thrown away. And they had to complete the 18-month course and online and all that. So if these persons were already in employment on 2007, then our clarification will come to their benefit.
Clarification, if my lords could kindly see paragraph 3, which is the cause of concern. If my lords could please see paragraph 3.
And you did not have, maybe you did not have the benefit, but Mr. Sethi had the benefit of arguing that matter.
My lords, the matter now, I'm the helping the matters, I may not be able to give assistance.
Yes, we appeal his arguments.
My lords, may kindly see
para 3.
However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10/8/2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. So the purpose, my lords, my limited understanding is that it had to be for institutions or for promotional avenues. At the same point in time, by the parent judgment, my lords upheld those rules as well. So my lords, the new fresh counselling has happened as per the rules.
So therefore, if there are any vacancies to be filled by the state government and they are already working in some institution on a cut-off date, then they are intendedly considered for migration from one institute to another institute, or if they are in the state government for the purpose of promotional benefits. And if you have 278 vacancies What is the harm in not considering them? We don't say that you appoint them. So consider them their claim.
Whereas none of the individuals up till now, we have received any submissions with respect to what already there that any individual was removed from service or denied promotion as a direct consequence of the parent judgment. Please see my rules, my lords. My rules have been upheld. My lords, please see paragraph 15, my counter affidavit, and see the rules.
Madam, we have upheld, but at the same time, we have also clarified that all those persons who were in employment as on 10th of August 2017 will be considered as having an eligible diploma if they have completed 18 months for all purposes.
Malas, for the purpose, that's what I see Malas clarification, since it said promotional avenues, which basically would have meant that in the
In other institutions would also include the government.
Malas, Malas will kindly see my limited submission. Would it also mean for the Uttarakhand government?
Yes.
That Malas will kindly see. As I said, my lords, the judgment was passed by my lords, and I will be just seeking my lords, rather, it's the other way around. I am seeking my lords' assistance. My lords, may kindly see my counter affidavit.
We will provide you the necessary assistance.
My lords, guidance, a better word, my lords. But, my lords, paragraph 14 and 15 is my counter affidavit, my lords. See the predicament. My lords, just see the predicament.
We are not directing you to appoint them, we are only directing you to consider their claim.
Malas, which would tantamount to what all the process that has happened up till the counselling.
We are not touching that counselling process.
He has been very clear on that. He himself said limited to the vacancies which are left out now.
So, my lords, in which case, all I'm left with is passing of issuance of joining letters.
No, consider them. Counseling you.
My lords, merit list would go.
We are not. Madam, you should have been attentive to what they said. Mr. Shankar Narayan was candid enough to say that he doesn't want to disturb the process which has already been completed.
I could say, my lords, but my instructions are this, that if you're going to consider and open it for these candidates that my learned senior is appearing for, it would have an impact on the list that has been prepared and the counsellings that have...
When he is also requesting that there should not be impact, and when we have clarified that there won't be an impact on the selection already done.
My lords, the process, if my limited understanding would be that if there are X number of candidates and the Y are being added to the pool, the list will have to be looked into.
Even if you clarified under 142, not a YE.
Very well, my lords. Very well.
Why I don't know what has happened to state of Uttarakhand today.
My lords, may clarify, my lords. My lords, I'm just...
We'll have to pass a community order inviting you Chief Secretary.
My lords, that may not need it. If my lords may kindly consider.
He has been candid enough. Still you are saying you will have to disturb the selection already.
My lords, I'm just trying to perhaps buttress my case with respect to the technicalities. However, if my lords are clarifying in order.
Just to help Ms. Shukla, there is no examination, etc. It's just that if you're eligible, you come. Now, if they add a question of a glut of applicants, then there may be some issue they face. At the moment, there are 278 vacancies. We are 239. If Ms. Shukla is right, they will have to open the door and just appoint us. That's exactly what will take place. But these are the applicants we were lordship is seeking enforcement of.
No, appoint us if you are otherwise eligible. Otherwise eligible, and we don't know. They might be having an interview process.
If you're not eligible, then the question doesn't arise.
That's right. That's what it is.
The applicants have approached this court for a direction to permit the applicants for holding the 18-month D.El.Ed qualification, the D.El.Ed qualification from Nios under the online diploma. What is line? ODL.
D.El.
Online distance learning.
Open distance learning.
Open distance learning. Open distance learning mode to participate in the counseling process and for appointing to the vacant post in the ongoing recruitment. Paragraph. The case has a checkered history. Paragraph. What is the date of our judgment?
Original judgment is 28/11/23, clarified on 10/12/24.
Why our judgment and order dated 20th of November 2023. We had upheld the rules framed by the Uttarakhand government which provided that for being eligible, be appointed as teachers, it was necessary to have a diploma course of 2 years
Or equivalent.
or
Question also.
or equivalent course. However, in the judgment itself, we had clarified that the scheme was initiated by the Union of India for providing we had clarified that the scheme which was run by Union of India was done in order to provide one-time opportunity to such of the teachers who were already in employment on 10th of August 2017 to get a qualification of a diploma course. Most of them. We are also held that the deadline of 18 months, the period of 18 months was specified in order to meet the deadline of appointing the teachers under the Right to Education Act, so and so. Correct. It appears that there was some confusion in some states, and therefore review applications were filed. We declined to entertain the review application on the ground that the judgment was clear enough, and it held that one-time scheme was provided solely to safeguard the interests of those teachers who were employed as on 10th of August 2017. We further clarified as para 3 and 4. The grievance of the petitioner is that though they are eligible as per the original judgment of this court dated 20th of November 2023 and the clarification dated 10th of December 2024, in as much as the advertisement is dated
29th May 2024.
29th May 2024. That is, after the judgment was delivered on 20th of November 2023, the state is not considering their claim. It is submitted that in the reply given by the state government, it is stated that the selection process is already complete and therefore the claim of the petitioner cannot be considered. Shri Narayan further submits that. Shankar Narayan further submits that the information received under the Right to Information Act would reveal that there are 278 posts vacant and the number of applicants is 265. 39. Correct. 3. Shankar Narayan fairly stated that the applicants do not intend to effect the selection process already done. Correct. Ms. Vanshija Shukla, the learned counsel appearing on behalf of the state, on the contrary, submit that while the judgment dated 20th of November 2023, this court had upheld the rules of Uttarakhand state, which provided that the 2 years qualification was 2 years, the diploma in education of 2 years duration was necessary for being appointed as teachers. He further submitted that any interference at this stage would cause the complications in the selection process already done. Correct. No doubt that we have upheld the rules framed by the state government by our judgment dated 20th of November 2023. However, at the same time, we had clarified that such of the teachers who are already in employment on 10th of August 2017 would be entitled to the benefit of one-time scheme floated by the Union of India. And if they had completed, we held that such of the teachers who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. Undisputedly, other institutions would also include the schools run by the state government. Also, we find that the case of the present applicant would be considered would be covered by our clarification dated 10th of December 2024. We therefore direct the state government to consider the claims of the applicants in accordance with our judgment and order dated in our clarification dated 10th of December 2024. And if the petitioners are found to be eligible, the applicants are found to be eligible to appoint them in accordance with law. We further clarify that while doing so, the state should not reopen the selection already done and which have reached finality.
My lords, also, if the contempt will not be pressed because now placing them, my lords, if it's just
so we can dispose of them. No.
Submission.
So these are transfer applications. So now, in view,
We have tried any contempt.
Then constructed, maybe not as a starter, but there are contempts by identical situation.
That's division. That's not.
That's in a different.
My lords, if at all, then in that case,
So this is a transfer application. So transfer is sort of what a writ petition.
Yes, none of us have.
You can now withdraw the writ petition itself in way of things.
The Lordship can treat the transfer petition at this course.
Yes.
The main transfer petition can carry. But this can be made time bound.
The same shall be done within a period of 3 months from today.
There's a little more time, my lords, not being granted because, my lords, my lords.
I was asking for a little less.
My lords,
The session will start. The children have to study.
my lords.
New academic year.
If we invite your chief secretary on 19th, it will be done within 15 days.
My lords,
If you want, then we'll do it.
my lords, I would not be able to
It's
speak.
only with an intention to expedite the whole thing. That's what it is.
So to उसमें transfer application is also taken on board. In view of the opposite order, no orders are necessary to be passed in the transfer petition. We further find that the grievance of the petitioner would stand, the grievance of the petitioner as raised in the writ petition would stand satisfied with opposite observation, and the writ petitions also stand disposed of in terms of the opposite order. So there is no question of contempt.
Mr. Kalra is appearing before this record as well. That's what I'm saying, and you've made that submission in the other matters also. You will be pressing the judgment.